Good morning, everybody. Thank you for joining us today for the New South Wales Local Government edition of our HR Breakfast Club. My name is Rachel Archer and I'm the Client Services Manager within the Employment Law and Investigations Group at BAL Lawyers. We have a slightly different platform this morning than our previous webinar, so please bear with us as we're all still learning. Throughout the webinar, if you're able to type any questions you may have in the Q&A box, which is the icon at the bottom of your screen, rather than the chat box, we'll try to get to your questions throughout the presentation and at the end. You can also use the hand raise feature, which should be the icon at the bottom of the screen as well. Our guest speaker this morning is Gabrielle Sullivan, who is the Director and New South Wales Accredited Specialist within our Employment Law and Investigations team. Welcome, Gabrielle. Are you there?
I'm here, Rachel. Hello.
Hello.
Welcome, everybody. Well, good morning, everybody, and it's a pleasure to be here. Just a moment while I'm going to share my screen and you can see what we've got prepared for you for this morning. Just bear with me. Okay, I think I've got the right one. There we go. Right, well, good morning, everybody. I met some of you at our HR Breakfast Club last month when we did COVID Part 1, as it were, Employment Law Answers for HR Managers, specifically tailored for those of you in New South Wales Local Government. A lot's happened in the month that it's been since that, so we thought it was timely to deliver an update for your benefit, but also because, as I said at the last session, Bradley Allen Love has had an enduring interest in local government over, frankly, the past 20 years. We do like to reach out to our clients. We know that's pretty difficult if you're in New South Wales local government because you're all over the place. We've got clients right down the south coast. We've got them right across the Murray River area along the border there, right out to Broken Hill. We don't really cover the Sydney metropolitan area or pretty much north of Sydney. But other than that, we've had contact with most of you over the course of those years, and it's always a pleasure working with you. But in these times, webinars are the way to go. So without further ado, let's try and get into it because we've got a fair bit to cover. You have to bear with my techno illiteracy. I am learning, and Rachel Archer will help me along if I need some help. Just shout out if you've got any techno issues. So in terms of what we're going to do today, I will try and stick to time. I appreciate the webinars are a really difficult way in some ways of learning and dialoguing. Bradley Allen Love holds an HR Breakfast Club for our non-local government clients. We do that on the first Friday of every month, and it's really a forum. It's really a dialogue forum. It's an opportunity for HR managers to get together and really chat through some common issues and tap into our expertise there. That's much better done in person. It's a little bit difficult in a one-way sort of forum, but as Rachel said, you can try and put your hand up or prefer put your questions in the question box and I'll see what I can do to answer it. It's difficult for a whole range of reasons, not least of which is my work from home screen setup, but I'll try and pause a couple of times along the way for questions and at the end. And following last month's webinar, there were some questions that were outstanding, and I've tried to tackle those in the course of this session. So that's what's going to happen. In terms of what I wanted to do this morning, though, I thought it would be helpful, firstly, just to recap on where we got to as at 8th of April, because that's the last time I did this webinar. Some of you on this webinar this morning weren't there, so I'm not going to double up. That's available on our HR Breakfast Club webpage there if you want to see the video recording of that presentation. But I will just summarise it in the slide because it helps us. That's where we were at the 8th of April. Since then, there's been some pretty important developments JobKeeper at the Commonwealth level. Obviously, the Splinter Interim Award is something that you would all be interested in. We've had the NCCC release of the COVID Safe Planning tool to deliver some WHS solutions for you all. Of course, the public health orders keep changing, and that has implications for you in the HR management space. And there's been some movements in terms of childcare payments from the New South Wales local government that are particularly relevant. Sorry, from the New South Wales local government, from the New South Wales government that are relevant to you in local government. I'm not going to touch on that other than just to point that out, but there's some developments that have happened. I'm going to pack the more important ones of those throughout the course of this presentation to get you up to speed on where we're up to. And then we're going to just move slightly and just have a bit of a think about some return to work issues from a WHS perspective. Obviously, there is some movement in terms of return to work. Things are looking up, thankfully, but there are some, obviously, some tough WHS considerations there. We're just going to touch on that briefly in the time that we have. And I'll hand back to Rachel at the end, and she can give you some details for our upcoming HR Breakfast Club for local government next month. So that's the plan. Let's have a look. Let's just quickly recap. Just as soon as mouse. Right, what happened last time? So this is a recap of session 1. I've just picked out what I think it's always helpful to remind you of. And the first point I made is that when you're answering any HR question in a local government, it's important that you remember the entire regulatory framework that applies to the decision you're about to make. Of course, that's difficult, but if you can just remember, you must consider the relevant legislation. So, for example, the Industrial Relations Act, the Work Health and Safety Act, and now the public health orders. So what does the legislation have to say about the problem I'm trying to solve? What does the award have to say? And I'll talk about the impact of the Splinter Award, but there's another source of regulatory obligation that you must bear in mind. What does the employee's contract have to say? So if you're senior staff, how does that bear on the problem I'm trying to solve? And finally, look at our internal policy instruments. Do they have anything to say about the problem that I'm trying to solve as an HR manager? It's a really good point to take away with you, that if a lot of the problems we're trying to solve now are novel problems and we don't have the answer in the law. What I'm trying to tell you, though, is to solve those problems. That's the framework that you'll need to continually keep referring back to solve those problems. So just don't forget that. That's a difficult thing to do, but quite often common mistakes are just to go to one source or the other. We'll just go to the contract. We won't read, or we'll just go to the award. We don't look at broader considerations. So that was my key point, and I unpacked that more fully, but just bear that in mind. We touched on your WHS obligations, and the good news there is that it's harmonised. So New South Wales, you're not particularly special there. The obligations that apply to you apply pretty much right across the country, and just pointed out really, as far as WHS goes, both employers and employees have obligations in that regard. We looked at what flexibility options were around as at the 8th of April. So we looked at working from home, and that's interesting because as at the 31st of March, the public health required that people work from home unless they could not do so. That's changed. I'm going to pick that up today, where we're up to with work from home. We went through the leave provisions in your state government award and pointed out that as at the 8th of April, there was no Splinter Award. There was a joint statement of intent, a policy talking about the unions and employers associations' preferred policy on the handling of special paid leave to deal with COVID. That's since been articulated in the Splinter Award, so I'm really going to talk you through that this morning. We touched briefly on variations to pay and hours and duties, which pretty much as per the Local Government State Award and redundancy and termination issues. Finally, stand down, as it stood, as at 8th of April, stand down required us to look at the legislation, specifically the Industrial Relations Act. There's nothing in the Local Government Award about it of any relevance. As at the 8th of April, if you as a council wanted to stand down employees because they had no useful work to do for a cause for which they were not responsible, then you're entitled to make an application to the Industrial Relations Commission to see if you could stand them down. Now, that's where matters were at. What I want to talk about is how is that changed, because there have been significant changes to those things. Let's go through those changes. Sorry, just bear with me. Obviously, one of the biggest changes, so that's 8th of April. 9th of April, JobKeeper was handed down. Now, I'm sure I don't need to tell you that JobKeeper doesn't apply to local government. That wasn't particularly well known at the time, and it took a while to flush itself out, and obviously local government were not particularly pleased. So I don't want to take too much time in this presentation talking about it, but I did think just flag it because it really is setting a Commonwealth benchmark, and you'll at least be able to see where local government sits in relation to that. In a nutshell, JobKeeper in one slide is simply that employers receive the $1,500 per fortnight from the Commonwealth, provided that they, sorry, I'm just going to, excuse me a minute. Thank you, just hiding my video so I can read my slides. Eligible employers will receive $1,500 per fortnight from the Commonwealth for their eligible employees, provided they satisfy the wage condition for the fortnight for that employee. So it's $750 a week for eligible employers, which in short are employees that have experienced a 30% downturn in their GST. Excuse me. So JobKeeper, if you've experienced a 30% downturn in your revenue, you're eligible for JobKeeper payment for most of your employees. There's a few exclusions, casuals and whatnot. That is the JobKeeper payment that's obviously attracted a lot of attention. In addition to the JobKeeper payment, the JobKeeper changes that came in effect from the 9th of April and last for a 6-month period until 27th of September, also brought in a range of employer flexibility provisions that are not at all dissimilar to what's happening in the Splinter Award. In a nutshell, the JobKeeper, if you're a JobKeeper eligible employer, you can issue directions to your employees to stand them down without pay, subject to paying the $1,500 per fortnight. A few qualifiers to that, but I won't go into it for now. You can issue directions that you change their duties, and you can issue directions that they change the location of their work. That does not require the employee's agreement. It's a direction that an employer can make. There's some qualifiers on it, but that's it. There's also provision in the JobKeeper changes to the Fair Work Act that employers and employees can agree to change the pattern of their hours or to take accrued annual leave at half pay as long as they still end up with 2 weeks left. So that's JobKeeper. As I said, it doesn't apply to local government, but obviously it set a pretty important talking point for local government. So what happened? How did they respond? Well, they came in with the Local Government COVID-19 Splinter Award. So I just thought I'd take you through some of the key features of that. I'd be very keen to hear your experiences of how you're going with that. So the Splinter Award applies, so JobKeeper's for 6 months. The Splinter Award's going to apply for 12 months. It's not to say it couldn't be extended, but the minimum period for an award in New South Wales is 12 months, so you've got a 12-month Splinter Award there. It's binding on those who opt into it. So at the moment, a lot of councils have opted in, and I had a quick look on my list of attendees this morning. The majority of you are working for councils or at councils that are named respondents to the Splinter Award. A couple of you are not. Obviously, that's a matter for your council to decide. Seems the key players have signed up to it. I think Wollongong's still holding out. I wouldn't claim to be up to date on that one, but what you need to know though is did my council sign up to this Splinter Award? Because if they did, you need to listen to what I'm saying. If they didn't, then you still need to comply, obviously, with the Local Government State Award, with all the other legislative developments, the WHS and those other framework instruments that I talked about, but the Splinter Award won't be irrelevant to you now. It's not to say that your employer mightn't choose to opt in the future, in which case then these provisions will become very relevant to you. So that's who it covers. What are the key features? Look, really unsurprisingly, not that dissimilar to JobKeeper. There's some flexibility provisions there for employers that allow them to make alternative work arrangements with their staff, make some directions about work from home, and accessing leave. Similarly with JobKeeper, there's also a provision that will allow employers to stand down their employees in exchange for a payment regime that's to be implemented in 3 stages. Firstly, there'll be some special leave will be taken first. If that's exhausted, then there'll be a job retention allowance for 13 weeks at the $858.20 per week. And if that's exhausted and there's still no useful work to do, then those staff will be on leave without pay. Don't worry, I'm going to unpack that, but for the minute I just wanted to give you a quick overview as to what that's the key feature in a slide. So let's just talk quickly about the application issues. Where there's any inconsistency between the Splinter Award and the Local Government State Award, the Splinter Award will prevail. Where the Splinter Award is silent, the Local Government State Award will apply. And there's nothing about the Splinter Award that prevents changes to working arrangements under the Local Government State Award. So in the last presentation, I talked about the family flexibility provisions that you already have in the Local Government Award under Clause 22. I didn't mention phased retirement provisions at Clause 23 or the job share provisions at Clause 27, for example. But when you pull out your Local Government Splinter Award, the point is don't forget you've still got quite a range of flexibility provisions under the Local Government Award, and it's not intended that the Splinter Award would prevent those arrangements or powers being exercised. A rather curious statement in the Splinter Award is also that, as a statement of intent, the Splinter Award is not meant to make employees worse off than under the Local Government State Award, and that if that situation were to arise, it could only occur by exercising rights under the Splinter Award and only as a result of a Commonwealth or state order related to COVID-19 responses. As I said, that's a statement of intent. I've just put some question marks there because I'm not sure how exactly that's going to apply in practice. I can see lots of disputes coming up, particularly where noting that where the rights are to be exercised as a result of Commonwealth or state orders relating to COVID responses, often the orders issued are narrower than what the employer requires. So there's a point of difference there that could lead to disputation. It's early days yet. We're starting to see on the JobKeeper front some disputes coming through the Fair Work Commission. I really haven't had the chance to catch up on what's happening in the New South Wales Industrial Relations Commission with disputes here, but just bear that in mind for the moment, and I can see some disputes down the track. So that's how it's meant to apply. Let's just quickly look at some of the key provisions. Remember, I said essentially there's flexibility provisions and there's some payment provisions accompanied with stand down. Let's just quickly look at those flexibility provisions first. Councils, one of the key provisions is suitable alternative duties, and that is that the award allows councils to issue a direction to an employee to carry out suitable alternative duties due to COVID-19. There's a list in the award of exactly what suitable alternative duties comprises of, and that is extensive. So it's duties within the limits of an employee's skill, competence or training, and or duties that could be same or different, that have a different span of ordinary hours, different spread of ordinary hours, different commencing and finishing times. There's some qualifiers there, but you can see that that's quite broad. The duties can involve working a different number of hours per day, and suitable alternative duties might in fact be training, including training in areas unrelated to an employee's substantive role. So suitable alternative duties is pretty broad. There's some qualifiers that I want to talk about, but just before I do that, just bear in mind that the ability for council to issue those directions has to be connected to COVID-19. It has to be due to COVID-19. So that's the only basis on which these powers come into play. You can see some causation disputes down the track as well. And in fact, the entire Splinter Award, really the changes can really only come in effect due to COVID-19 as defined. So just on the suitable alternative duties, I said to you there were some qualifiers there. Council can issue a direction, so it doesn't have to be agreed to. The direction, we're the employer and we're issuing a direction that the Splinter Award now says is lawful and reasonable. The direction cannot be unreasonable, having a regard to the employee's personal circumstances. So of course you have to take into account their family and carers' responsibilities, and obviously that's a difficult. It's been a difficult path to navigate, I know, for plenty of you, both personally and professionally. Thank God school's going back, right? So hopefully some of those will at least ameliorate a little. So if you issue that direction for alternative duties, what do you get paid? They've thought it through. You'll be paid at the rate that recognises the skills the employee is required to apply to those duties. So, but the employer shall not suffer a reduction in pay from the substantive decision. So what it means is you can't be paid less than what you're already paid. If you're exercising higher skill that attracts a higher pay rate, you could be paid more. As for allowances, you will be entitled to your allowances, your weekend penalties, and your shift penalties that apply to the new duties, not your old duties. And interestingly, if the employer issues the direction, it's not unreasonable, having regard to the employee's personal circumstances, and they don't want to comply with it. What happens? Well, at the very least, they would not be entitled to special leave or the job retention allowance, which are the features of the stand down provisions coming down the track. So, so that's, sorry, I'm just, oopsie. Oh dear. I'm not sure how that one got in, Rachel. My co-workers and me ready for another day of Zoom meetings. Sorry, that wasn't supposed to happen. Let me just work it. Brilliant. Okay. They're not even social distancing. Right. So we were talking about suitable alternative duties. Okay. so that's one of the key flexibility provisions. Just before I whiz on to work from home, I did also want to mention a couple of minor changes to annual leave and long service leave arising out of the Splinter Award. And that is, if I've just got a slide there that shows you the award, the existing local government state award provision, and then the little Splinter Award change there I've highlighted. So just to recap on last time, already in the award, employers can direct an employee to take their annual leave where they've got excessive leave accruals, right? And they give notice. What the Splinter Award does is it allows the parties to agree to take annual leave at half pay. So that's not a direction, that's an agreement, modest help. And in the long service leave arena, the existing local government award, clause 21E, did allow employers to direct employees to take their long service leave, again, where there were excessive accruals. The Splinter Award will allow an employee with less than 5 years service to take their long service leave in advance with the employer's consent. So there's a couple of minor changes there. I did want to move on to work from home, but before I do that, I might just pause for a moment and just check my little, I'll give you a little moment. There you go. Now you can have a look at your co-workers while I just have a check with Rachel. We'll see how the questions are looking. So go and get your cup of tea for a minute. It does take us just a little moment, just because of our remote setup. So I'm going to switch the camera off for a moment and we'll reconvene just probably 2 minutes. Okay, I'll be back with you shortly.
Okay, welcome back everybody. Thank you for that, Gabrielle. We just have a few questions in the Q&A box if you'd like to run through those now, or would you like to leave them to the end of the presentation?
I'm happy for you to just ask them now, Rachel. We'll see how we go.
No problem.
Yep.
So the first question has come through from Kim, so thank you very much, Kim. If possible, can you please define what a regular casual is?
That's $1 million question. And I definitely have to do a bit more research. It is the subject, certainly at the Commonwealth level, the definition of a casual in general is up for grabs in the Scheme and Work Pack case that you've probably all heard about. Regular and systematic casual is actually the phrase that's used at a Commonwealth level. At a state level, it may well have a different meaning. I suppose I would like to give you a simple answer. I cannot. A, because it depends on context, and B, because the law is in a state of flux. What I would say, though, is that casual, by definition, usually means intermittent, no fixed assurance of work in the future. So if there are rostering arrangements that roster you on a regular basis into the future, that will raise questions about the casual nature of the work, and as to it being regular, systematic, that also bears on that question. So I'm sorry to be a little bit less than helpful there. I probably need to know a little bit more about the exact purpose you're asking me for, but look at, is there an absence of a firm advance commitment as to work? And if the answer to that is yes, then you've probably got a casual. And as to their regular, look at the rostering arrangements.
Okay, thank you, Gabrielle.
Yep.
And our second question has come through from Claire, so thank you very much, Claire. Has a question regarding returning to the office in the future. If an employee refuses to return to the office as it's not safe in their eyes, and the council has complied with all of the orders and risk management practices, can they direct them to do so?
Well. We've had that question a few times. I think we tackled that one maybe even last time. I've been asked it a lot. And we are going to, I want to unpack that a little bit more in more detail, Rachel. We're going to move into work from home in a sec, because that question's on everybody's mind. But I suppose to just cut a long story short, the touchstone with all these decisions is reasonableness. If council is acting reasonably and lawfully, and employee takes a different view just because in their wisdom then there's no reasonable basis for it, then they're in trouble. They're not complying with the lawful and reasonable direction, and there are disciplinary consequences that can flow from that. And certainly if they're not cooperating in work health and safety policies of employers, that's actually a statutory breach of the Work Health and Safety Act. So there are definitely tools to manage that sort of recalcitrance, but the touchstone is reasonableness. Why do they say it's unsafe? And can I say, certainly in Canberra here, I've seen in private practice, we have had plenty of employers not taking it seriously, not really exposing employees to unsafe work practices. And they contacted me, and my advice was, no, you don't have to go back. That's ridiculous. They're not social distancing, etc. It's unsafe. It's fair enough. So act reasonably, Claire, and all will be well. Simple.
Okay.
Right, what else, Rachel?
Okay, we have another question from Des. So again, thank you, Des. What are the implications for my council as we have not become a signatory for the Splinter Award, as we see this as something that will create a significant rift within small communities and virtual guarantee of employment for up to 4 months?
Oh, Des. I'm a lawyer. You can't ask me political questions. I guess there's a lot I could say to that, but that would be in my personal capacity, not my professional capacity. So certainly there's a lot of politics here, isn't there? And that's actually kind of a really good point. Why do they get 4 months when other people get nothing? And well, arguably they're getting 6 months under JobKeeper. But anyway, look, I suppose I'd say that's a political question, Des. Good luck with that one. Okay. Thanks, Rach. We better get into it. Time.
No problem. Yeah, I will switch my camera off and back over to you, Gab.
Okay. All right. So, where do we get to? Let's see. Sorry, I should be. There we were. Okay, we were working from home, weren't we? Now, so working from home. Okay, folks. So look, we've got about 20 minutes to go. So I did want to tackle on that working from home scenario a little bit. One of the questions we get is, do workers have to work from home? That's changed.
Sorry, Gab, you just need to share your screen.
Oh,
so the presentation will come back up. Okay, perfect. Thank you, Gab.
Okay, sorry, folks. Right. Now, what we're talking about working from home. Do you have to? This is a moving feast, this one. I said to you right at the start, there's various sources or framework documents you need to look at to answer these questions, as you're probably all becoming increasingly aware. It was a requirement as at 31st of March that workers did have to work from home unless they cannot work from home. That was as at 31st of March. Under the public orders that came into effect, public health orders that came into effect as a matter of legislation on Friday, the 15th of May, you don't have to work from home. But what it actually says, employer must allow an employee to work from home where it is reasonably practicable to do so. Sigh, right? What does that mean? Look, obviously there's no case law about that yet. I'm sure you'll all be very sensible. Reasonably practicable, of course, is the language of the WHS legislation. In that field, at least, reasonably practicable is something that's narrower than that which is physically possible or feasible. So you don't have to go that far. It's an objective test. What would the reasonable employer do? Would they allow work from home in that situation, bearing in mind the usual sort of considerations and based on what's known at the time, based on what is known at the time. So that's the public health order. But of course, that may well not be the law in a week's time, but that's what it is as at today. And just FYI there, my take of that public health order in New South Wales is that the requirement is that the employer must allow an employee to work from home where it's reasonably practicable to do so. The word allow imports a request, because allow means to grant permission for. That implies to me that the employee actually asks for it. So this is where the employee asks for it. So do they have to work from home as a matter of compliance with the public health orders? Well, if they ask and it's reasonably practicable. But as a matter of award, do they have to work from home? Well, as we discussed last time, your local government award, existing local government award, not the Splinter Award, has a raft of flexibility provisions in there that allow employees, they've always been able to request working from home, and that's determined by council, considering cost, productivity, impact, etc., the usual sort of things. What the Splinter Award does, so that really, so the existing local government award assumes the employer wants to make the request. What the Splinter Award does really is allows the employer to make that decision. So it's more about the employer asking than the employee. What the Splinter Award says is where, due to COVID-19, employees are unable to perform their normal duties at their normal place of work, the employer shall explore opportunities for affected employees to work from home or from another location, and or provide the employee with the suitable alternative duties I discussed earlier, and review these arrangements. And then the stick in the Splinter Award is that employees who do not wish to comply with the opportunities the employer so identified, for example, to work from home, if they don't want to do it, then at least they're not entitled to special leave or job retention allowance payments. And there may well be additional consequences as well, but there's at least that. So that's working from home. Let's check my time. Okay, still got a few minutes. So if you are working from home though, as you probably have intuited, a lot of councils have just been doing this anyway, if you are working from home, employees not entitled to shift or weekend penalties unless they're directed to work outside their ordinary span or spread of hours. Ordinary hours can't exceed 12 hours in any day, and you're not entitled to reimbursement of your home internet or computer related expenses unless you've got special circumstances and that's been prior approved. You can claim your out-of-pocket expenses for your stationery and whatnot in accordance with the local government award, and presumably as a tax deduction. So that's the story with working from home. I did want to touch just quickly on the stand down direction. So work from home, alternative duties, etc. That's shuffling the deck chairs around. What happens if we get to a point where there is no useful work to do because of any act or omission for which the employers are not responsible? So the pool has been cleaned to within an inch of its life. The library has, never been catalogued so well, and we're really out of work. And I think libraries they're all back on their way up, aren't they? But we just don't know when this is going to come and go, right? Second wave, etc. So the Splinter Act makes provisions for stand down. Just to recap, prior to the Splinter Act coming into play, there was provision under the Industrial Relations Act for employers to stand down employees who couldn't perform useful work on an unpaid basis. What the Splinter Award has done, those that are bound by it, the Splinter Award allows employers to stand the employee down in full or in part because of COVID-19 only. And they may temporarily do that, so for up to 12 months, subject to payment of the following amounts. So up until now, you would have been stood down with no pay, subject to any award by the Commission to the contrary. But under the award now, under the Splinter Award, what will happen is for the first 4 weeks of the stand down, you will get paid the COVID special leave payment, which is 4 weeks max at your usual rate of pay. Stage 2, you will get your flat payment of your job retention allowance for up to 13 weeks, which is, I think that's $858.20 per week. You can top it up with your leave and whatnot, but it's a flat payment for everybody for up to the 3 months. So you've got the 4 weeks special leave, then the 3 months job retention allowance, and then if you still can't be usefully employed, your employment's not terminated. You are stood down on leave without pay. So that's the local government equivalent to JobKeeper, as it were. I could say a fair bit more about that, but I'm just mindful of the time. So if you've got a question, just chop it through and make sure we'll try and call it up. I just wanted to just quickly let you know, oh yeah, look, in terms of you can be recalled on 24 hours notice. So you stood down, they go, actually, no, we've found a job over here, come back. Special leave, when you're on that 4-week special leave, stage 1, as it were, that counts as service and it'll count for super, we think. That's what the award says, for what the tax office says, but we'll assume that's the case. When you're in stage 2, a period on the job retention allowance, that doesn't count as service, and you don't get super on nothing, obviously. So that's just a couple of things to think about in that unpleasant scenario. I did say I'm just going to do it in 2 slides, just on the return to work issues, because that's sort of relatively exciting and hugely challenging task that's before a lot of HR managers at the moment. How do we get all this right? Look, we could spend days talking about this. I did go through WHS more generally a month ago, just reminding of your core obligations to identify, assess, control, review, make sure you're complying with the public health alerts, etc. Since then, to help you along your way, New South Wales Local Government has got a fair amount of resources that aren't too bad. I had a look to help you with WHS decisions, relatively sophisticated and sort of statewide. There's also, of course, the NCCC's COVID Safe Planning Tool was released about a week or so ago that might assist you. I haven't looked at it from a local government perspective. I'd be interested to hear your feedback on that. I suppose just, like I said, there's so much I could say, but just in one slide, I suppose obviously the key priority here is to conduct your risk assessment, to identify the risk and to adopt the control measures regarding the risk of your workers contracting COVID from work. Right? That's the key risk. There's also mental health risks that are increasingly reasonably foreseeable, I suppose. And then there's this a priority, of course, being what are you going to do if there is a positive diagnosis at your workplace and you need to get your people, transition them back to remote working. So making sure you've got your pandemic plan in place. As I said, Bradley Allen Love, we work, we're Canberra based and we act for, in addition to local government and state and Commonwealth governments, we also act for private sector. They're a lot more, they struggle with that a lot more than councils, who are frankly better resourced to manage that. But just a few tips there. Don't forget your WHS consultation obligations in the flurry. Basic sort of concepts that people seem to be, in local government, seem to be well familiar with, thinking about staggered return to work, shifts, not everybody coming at the same time. What are the prerequisites we require before return to work? Do we need to sign off on health declarations? Do we really need, in some cases, temperature testing? Those sort of issues are all coming to the fore now. What are we going to do to make sure on any particular workplace that social distancing, your interaction protocols, your PPE and your hygiene measures are all both lawful, reasonable and safe. And making sure, of course, that this is not a set and forget thing. Ongoing monitoring is required because nobody wants to be the Victorian abattoir, do they, or Newmarch House here. So there's really a lot of work to be done in the WHS space, as I'm sure you're all aware of. I'm just looking at my time. We've got about 5-10 minutes left. So that will allow me just to be quiet for a little minute and just flick back, I'm just going to be quiet just for one moment, just go back and have a look at my questions and see if we can just tackle a few of those, if there's any that might appropriately be done so in this forum. So just give me a minute, folks. I'll just stop sharing for a moment and we'll be back in 1 or 2 minutes. Okay, so I've just checked in with Rachel. We don't have any more questions there for now. So I take that means you either know it all or you're totally exhausted, or we've all got so many other things to do. It's a really challenging time for HR at the moment, and things are really moving really quickly. If you think there's anything that we can do to help you through this, we're learning through this too, but as I said, we've been working with local government in the employment space and frankly planning and environmental procurement spaces as well for quite some time, and we'd be very pleased to hear from you. I am, as Rachel said at the start, I am an accredited specialist in employment and industrial law from the New South Wales Law Society, so we are in Canberra, but I do know my New South Wales law, and even better, I'm a country girl myself, a New South Wales country girl, so I understand. So look, I'm going to leave it there. I'm going to hand back to Rachel, and she's just going to let you know about the next HR Breakfast Club for local government. I would really hope that you can join us there, and as I said, I really hope in the not too distant future I can actually meet you in person. Okay, I hope you have a nice day. Bye-bye.
Okay, thank you very much for that, Gabrielle. Thank you everybody for joining us today. We will be hosting a further webinar next month on Tuesday the 16th of June. We will keep you informed of the topic, but if you do have any special requests, please just email us and let us know. This session has been recorded as well, so this will be posted on our HR Breakfast Club website, which is just hrbreakfastclub.com.au. And like Gabrielle says, if you have any further questions, please just email us. Thanks once again, please stay safe, and hopefully we'll speak to you soon. Bye.